After 1,775 days, the case of dee-Warner's murder could soon come to a close. Thanks for joining us here on WTOL 11 Plus. I'm Jeff Smith.
And I'm Kaylee Marintet. Jury deliberations began today and will go into tomorrow. But before that, the prosecution and defense offered their closing arguments to the jurors.
And we're bringing you an in-depth legal analysis on all of this in just a moment. But before we get to that, here's Melissa Andrews with the very latest from Lenawee County.
Prosecutors told jurors the evidence shows a pattern of control leading up to dee-Warner's death. They pointed to testimony that Dale Warner tracked his wife's movements thousands of times through her vehicle's location services, installed a GPS tracker on her vehicle, and tried to clone her phone.
That it's being accessed at 7:08 a.m. by Dale Warner. And what is being done on that app? The vehicle's being unlocked. We know Dee Warner kept her purse locked in her vehicle. Dale Warner says it himself on April 25th to Austin Hall. She keeps her car locked. She was looking for her keys. It's locked. Everything's a secret. Her purse has never been found.
They argued the couple's marriage was deteriorating and that Dee planned to confront Dale about divorce and selling their businesses the night before she disappeared. The state laid out a timeline they say shows Warner killed his wife inside their home the morning of April 25th, 2021, then used farm equipment to move her body to a spray barn on the property. Surveillance video, prosecutors say, shows him later gathering tools and welding equipment and spending more than 2 hours in that barn, time they believe he used to cut open and weld shut a tank containing her body.
Defendant duct taped her mouth and her nose so that she could not breathe again. Those were all conscious decisions. 1, 2, 3, 4. Every one of them. We want you to return a verdict of guilty first-degree murder and tampering with evidence.
The defense told jurors the state's case is built entirely on assumptions. Attorney Mary Chartier argued there is no physical evidence tying Warner to a killing, no blood, no signs of a struggle, and no proof that Dee Warner even died that day.
Now, as it relates to Dr. Cho, please remember that he said he could not tell by the condition of Ms. Warner's body what the date of death was. He couldn't tell the date, the month, or the year based on the body's condition. The only way that he gets to April 25th, 2021 is because that's when people tell him was the last time that Ms. Warner was seen. Ms. Warner's date of death is actually unknown because Dr. Cho could not determine it. Dr. Cho doesn't know the time of Ms. Warner's death. Dr. Cho does not know the place of Ms. Warner's death. Dr. Cho also does not know what caused the blunt force injuries.
She pointed to GPS data and surveillance showing Warner working throughout the day on farm equipment while multiple employees and family members were freely able to move around the property.
If he had killed his wife, is he really going to leave the property and let people roam around wherever they want? He goes out spraying. Numerous witnesses, including Mr. Lally, Zach Bach, and Raquel Bach, said that the Warners never locked their house. It was always unlocked, anyone could walk right in, and that's what they did on April 25th, 2021.
The defense also criticized investigators for failing to fully explore other potential suspects and argued the timeline prosecutors presented simply doesn't fit. In rebuttal, prosecutors said the timeline does work and argued Warner deliberately chose the spray barn because it had no cameras. They also said the lack of blood evidence is not unusual in cases involving blunt force trauma and strangulation. The jury got the case at 3:39 this afternoon, and they will begin deliberations here at the courthouse tomorrow morning starting at 9. Reporting in Adrian, Melissa Andrews, WTOL 11.
And as we have been doing throughout the course of this trial, we wanted to give you some in-depth legal analysis into all of this. So once again, we are glad to have with us former judge, former Lucas County Commissioner Gary Byers joining us in studio. You said you watched some of the closing arguments that took place today. Let's kind of set the stage for the viewers at home. What is the main goal going into today? What, as a prosecutor, as a defense attorney, are you trying to succeed with?
Sure, this is your last opportunity to connect with the jury and to explain the most...
Connect, you use that word, explain that.
Yeah, you want to convince them that your analysis of the case is the correct one, whether you're the prosecution who's put together this case based on evidence that is many years or several years old, or the defense attorney that is trying to point out inconsistencies or questions that are unanswered, and it's your last opportunity to try to connect those messages to the jury in a meaningful way so that you can either establish proof beyond a reasonable doubt or the reasonable doubt.
Is it as simplistic as it's a rerun of what we've had the last 4 weeks?
No, I usually consider the prosecutor gets the first closing and the last closing. The first closing I sort of viewed as a rerun of the evidence, and you go through everything that you had. The defense lawyer gets an opportunity to speak then, and she was able to lay out all of the inconsistencies or time gaps that they would like to focus on. And then the last word comes from the prosecutor, and that's the final rebuttal. That's the final argument that you get to make before the judge instructs on the law.
We have talked over the course of many weeks, Gary, talking about the differences in Ohio and in Michigan as far as murder is concerned. And you said something has stood out to you as far as the large ask of the prosecution was to prove premeditation. Yeah,
in a domestic violence case, which is effectively probably how this started, to show a premeditation, that prior calculation and planning is a very difficult thing from the prosecution. That doesn't mean that you can't show a purposeful killing, and they have tried to put together the circumstances and the evidence in order to support that analysis, but it's kind of a difficult effort to establish beyond a reasonable doubt.
So let me throw out a couple of things at you. There's going to be kind of a back and forth as far as enough, not enough. So a crumbling marriage.
That's relevant to set the circumstances, but that is not particularly evidence of the homicide.
Yeah, belligerence, belittling, things of that nature.
That is consistent with domestic violence. Again, domestic violence is not an offense of violence, it's an offense of control. And when you start to lose control in a domestic situation, that's where the violence occurs.
What about the personal opinions of the witnesses, to what they observed, what they took from it, the relationship we're talking?
I think to a jury, those have relatively low probative value. I think they want to listen to the evidence, they want to hear the hard facts, the timelines, the videotapes. They want to make the best calculation that they can as to what they can evaluate this evidence as to whether it constitutes proof beyond a reasonable doubt.
Yeah, premeditation. And we heard from Melissa's piece there, kind of wrapping things up. The defense came through and said, Dr. Cho didn't know this. Dr. Cho didn't know that. And then there was a third element to the actual analysis of the body. How much reasonable doubt does that place in a jury's mind when it comes to a medical examiner's prognosis?
Well,
or diagnosis?
Yeah, I mean, she was in a tank that was sealed up for years. So, it's not like you see on TV. I mean, there are limitations to what a coroner can do in evaluation of evidence. So they look at all of the physical evidence, but they also look to the circumstantial evidence that the investigation has given them, and they base a report based upon that. So, there's always going to be some questions. The fact that they couldn't, from the body alone, establish a time of death, or that doesn't mean much.
Let me take you, and we'll wrap up here. Let me take you into this next few stages, or the next stage specifically. And we heard tonight, after they were dismissed and sent home to return tomorrow on Friday, they asked for a number of exhibits. This is the jury wanting a number of exhibits back to re-examine, to talk, to discuss. Out of the ordinary, or is that very normal? Because there was some uncertainty about how quickly this verdict will come back.
Well, I mean, this is a serious case, and the jury is taking it seriously. They want to make sure they've reviewed all of the evidence. It's their collective recollection that is going to rule the day. Reviewing that evidence is showing diligence, from my evaluation, that they want to do the right thing. And most of the time, I find that juries do the right thing. And so the fact that they want to review that evidence, I think, is pretty normal.
But is there any read into time taken and you have seen over the course of your career, if it's a long deliberation, that's guilty?
Yeah,
Or is there no?
usually a long deliberation is to the benefit of the defense. Shorter deliberation usually goes towards the prosecutor, but these are people, and you can't always, there's no absolutes in jury work.
Yeah. Well, Gary, it has been a delight as we get the returns as far as when this verdict comes back. We hope we can call on you once again.
You bet, Jeff.
We appreciate it. Great insight once again. And we want to send things back over to Kaylee with what could come next. Kaylee?
Great insight there. Thanks, guys. Well, what's next is simple, but not easy. Waiting. Jury deliberations will continue tomorrow morning at 9 o'clock. That means the Lenawee County community is going to have to wait at least one more night to find out the verdict. But that's not stopping some people who live in the area from forming their own prediction on what that outcome will be. Michael Sandlin shares what some are saying.
Innocent or guilty? That's the question people here in Lenawee County are asking tonight as this years-long case finally comes to a close. The people I spoke with in town, both on and off camera, say all the evidence the prosecution has demonstrated points to one clear answer. Dale did it.
And there seems to be a lot of evidence towards Dale Warner doing this, and my feelings is that I think he's guilty.
I definitely think that he's guilty.
They were saying in this article that welding is never done in the barn, and he had it there. What's that?
I saw the picture of her wrapped up in the fertilizer tank, and I couldn't imagine doing that to my husband or someone I loved, and then to look the kids in their eyes and just not feel anything.
Now, it's hard to tell how long it's going to take for the jury to come back with that verdict, but once they do, we'll see if they agree with these people on the outside looking in. Reporting in Adrian, I'm Michael Sandlin, WTOL 11.
Well, once a verdict is reached, we will bring it to you live from the courtroom right here on WTOL 11+. And no matter what happens tomorrow, verdict or no verdict, we will be back right here at 6:35 to bring you the latest from Lenawee County. And we'll be joined by former assistant prosecutor and current assistant professor at professor of law at the University of Toledo, David Harold.
And don't forget, you can see how this case all unfolded from the very beginning right now by streaming Hidden in Plain Sight, the disappearance and discovery of Dee Warner, anytime on WTOL 11+. 11 Investigates sat down with Dee's family and broke down the entire investigation in a special 30-minute presentation.
That's it for us tonight. Make sure you're following us on all your favorite social media platforms. And as always, you can download our free WTOL 11 News app right to your phone.
Yeah, we appreciate the time you have spent learning more about this case, as we do as well. Have a good night.